The Telecommunication and Other Legislation Amendment Act of 2018 has amended a broad range of Commonwealth legislation to allow for law enforcement and national security agencies to request or compel assistance in certain matters from telecommunication providers. As per the Act's explanatory memorandum, the primary purpose is to facilitate access to data, devices, and systems that are otherwise subject to a warrant where this information would otherwise be inaccessible. It is important to know whether your company falls under the Encryption Act. Section 317C sets out a user-friendly table of 15 categories that are designated communication providers and explains what the eligible activities of those providers are. This is the catch-all definition which applies to a wide range of participants in the global communication supply chain that supplies communication services or products that are used or likely to be used in Australia. We strongly recommend that you take a second on this slide to see whether this Act covers you and your business. Section 317E of the Act lists the acts or things which you may be required to do when you receive a notice from interception agencies. The government and law enforcement bodies can request or compel you to do some of the following: remove a form of electronic protection that was introduced by a provider, conceal the fact that covert actions have taken place, or to install, maintain, test, and use software and equipment, and so forth. These acts can be requested of you by way of one of three notice and requests. Each notice differs from the other in its requirements and timeframes. A technical assistance request is a voluntary request with limited oversight. This can be issued by a Directors General of ACO, ASIS, ASD, or by the Chief Officer of an interception agency. A technical assistance notice is a compulsory notice for a designated communication provider to use an interception capability which they already have. This can be issued by the Director General of AACO or by the Chief Officer of an interception agency. Lastly, a technical capability notice is a compulsory notice for a designated communication provider to build a new interception capability to meet with a technical assistance notice. This can be issued by only the Attorney General after an ACO request or interception agency with the approval of Ministers of Communication. When complying with a notice and request, it is critical to be aware of the timeframe which you must comply with. Each compliance period is determined on a case-by-case basis and is decided in consultancy with the telecommunication provider and the interception agency. The default periods are as follows: 90 days for a technical assistance request, 90 days for a technical assistance notice, and 180 days for a technical capability notice. It is crucial to note that when a provider fails to comply with a notice, civil penalties will likely apply. The company can be liable to a penalty of up to $10 million and an individual can be liable for up to $50,000. The Act may seem overwhelming. However, the relevant government bodies and agencies provide assistance and work alongside the telecommunication providers when issuing or requesting information. For more information, please feel free to visit any of these following websites.